I know you folks don't understand what that is, but we've had some major snowstorms in the last couple of days, so I've been spending a lot of time outside with a shovel. Um, I thank you for joining today. Just a little bit about myself and who I am. Actually, you might be seeing me the whole time because I'm having trouble finding how to shut my camera off. A little bit, just I'm going to do an introduction of who I am so you know a little bit about what the 21st Century Cures Act is, and then shift into information blocking, what it might mean for you, some next steps, and then we'll take questions. I'll try to leave a fairly good amount of time at the end for questions. Um, I also know how busy you all are, so I want to try to get through this, including the questions, in a very reasonable amount of time. So I ask you that if you add questions at any time into the Q&A section, that's fine. I think what we're going to do, though, is hold them till the end. If there's something that's really confusing you, I can always go back and touch upon that as well. So a little bit about who I am. As Elise said, my name's David Bucciferro. I'm with Foothold Technology. We're a sister company of Exym for a few years now. I came to Foothold Technology about 8 years ago. I was the director of psychiatric rehabilitation services and outpatient services for the state of New York Office of Mental Health. In that role, I developed a number of outpatient programs, managed regulations and certification, and many other different areas, as well as being involved in some of the information gathering and reporting that we had to do to the federal government and to our governor's office. I then joined Foothold Technology as senior advisor. And last year I was elected as the vice chair of the Electronic Health Record Association, which really did put me in a nice spot where I was able to get involved in a lot of different areas that we were not all that involved in before. CURES being one of them, but many of the different areas, vaccine distribution, and many other different things that are coming with the CURES Act and the CARES Act, and just about every act that the federal government gets involved in. So that's who I am. My dad used to say, you don't ever have to introduce yourself because what you say is what people care about. And my mom used to always say, introduce yourself. So I did what mom always said to do. So again, if you have any concerns about the Information Act, the information rule, please type them in the Q&A section. I want to make sure at the end that we're able to touch upon those concerns. So what is the 21st Century CARES Act? I'm going to touch upon this CURES Act, in a number of different ways, and I'm going to focus all of our energy, though, on information blocking. So in December 13th, 2016, the administration put into law what is known as the 21st Century CURES Act. It's really a set of many, many, many different pieces of legislation and directions and focus that the government wanted to move healthcare in. It's really focused on accelerating research and prevention for curing illnesses. It had to do with accelerating treatment for drug and medical device development. There was a section that addressed opioid crisis. There was a piece that was partitioned off to improve mental health services. And there were a number of other different provisions that dealt with interoperability, adopting electronic health records, and trying to use them to support human service programs. So the 21st Century CURES Act is a huge thing. It's not just information blocking. They made a valiant attempt to deal with the opioid crisis. I think folks probably know that prior to the COVID outbreak, there was starting to be a reduction in the crisis that dealt with prescribed meds. Most of that has unfortunately been dwindling away very rapidly, and we're almost at the same place we were prior to COVID. It also dealt with 42 CFR Part 2 and requested that there be a change to that rule. For those of you who don't know, 42 CFR Part 2 is the protection for substance use information. There was a piece that was targeted towards HIPAA. There was stuff targeted towards behavioral health and the opioid crisis. Really, there was a recognition that to treat somebody, you needed a holistic view, which included their behavioral health information as well as their primary care. There was something called TEFCA, which was a framework for the way this information would be shared. Many of these have not come to fruition yet. I'll touch upon that a little bit later. But the real focus, the heart of what it was about, was making patients the center of their care through access, transparency, interoperability, and more. That was the real heart of what the 21st Century Cures Act was about. I will say that for those people who do not or are wondering, this administration's made many, many different changes. They've already stopped a lot of things from going through. They've delayed this act, for example, from taking effect for 60 days, I believe it is. President Biden was one of the largest promoters of this in Congress. He was given this task by President Obama to really push the 21st Century Cures Act through Congress and the Senate. He is a huge proponent of what the Cures Act is about. And if anything, we will start to see more of the Cures Act being implemented, not less. There are nuances, as we all know, about the way various parties approach certain parts of access to information. So there might be some little twist that we're going to be living with, but I'm going to give you the best information that I can that's available at this time. I just wanted to share this. This was Don Rucker, who was the national coordinator's statement, and I wanted to share it because Don's a doctor, but he had come to prior to resigning last month, he had come to ONC.
I'm sorry. I'm not seeing your slides change. Just want to make sure we're seeing what you're seeing.
Oh, you didn't see them change. Oh, I'm sorry. How's that, better?
Perfect.
Okay, it was on block. Thanks for letting me know that. The coordinator said promote healthcare choice, competition across the United States, advance interoperability, support access, exchange, and use of electronic health information. And I wanted to share this because he actually started one of the first EHRs in the country. He was one of the original people who started EHRs. And so he really held a position of believing that EHRs were the center of what could help. So let's start with a few questions that I hope we can put to rest today. This does not pertain to me. I do not use a certified EHR. I'll be in trouble if I don't comply on day one. I don't use a certified EHR, and I'm not a certified provider, so I don't have to comply. And I cannot provide the whole set of US CDI data elements that are being mandated. Hopefully, we're going to answer all those. If we don't, we'll deal with them in the end. So, information blocking. We're going to look at this in a couple of different definitions because it is complex. It's not a simple concept. I can tell you that there are just enormous amounts of committees and energy that has gone into trying to translate the act. I'm hoping that what does happen in the next 60 or 90 days will try to clarify a few of those areas that are still not well understood, even though it's being implemented, but we'll touch upon those as we go. So CURES is really the business or technical and organizational practice that stops people or discourages people from accessing their healthcare information or exchanging healthcare information or using healthcare information, in particular EHI, electronic health information. And they use a term called actors, which we'll talk about, and that an actor knowingly does this. And that an actor should know that their practice is interfering with the access. So there's a number of different pieces that have to be in place for something to actually be considered information blocking. So this is a definition I think that actually is a little bit clearer. It's more of a combination of taking the major points and putting them into some bullets here. So really it means a practice that, except required by law, are covered by an exemption. So in other words, if 42 CFR says you can't share something, you wouldn't share it unless that person gave you permission. You're stopping somebody from accessing their data or exchanging their data with a third party or using their health information for some beneficial purpose. If it's conducted by health information technology developer or an EHI exchange, such as an EHR developer or a health exchange developer, they should know that that practice is interfering with or materially discouraging it, and that would be considered an information blocking. So if they know that what they're doing is blocking information, then they would be considered an information blocker and be subject to the penalties of information blocking. Now, I don't want to make this sound like, you know, you could play dumb and say, oh, I didn't know that was something we had to share, because it actually doesn't work that way. You're expected to know the law, sort of like if you do something wrong with the law and you say, oh, I didn't know that was something bad to do, it doesn't really stop them from prosecuting you. So if it's conducted by a healthcare provider such as yourself, and you know that the practice is that you're making it unreasonable and it's interfering with or preventing or materially discouraging that information or the information of health and the electronic health information, then you're considered information blocking. Now, until May 22nd, 2022, and I believe this date will end up changing, the information that needs to be exchanged is the US CDI information. And I'm not going to get into what's in the US CDI. I'm more than happy to talk about it if we want to. At the end, the US CDI does make some pretty big changes that weren't in before. So what the law did was it gave roles to two of the major regulatory bodies in HHS, Health and Human Services. ONC's role in information blocking was creating principal objectives, enhancing interoperability, reducing clinic burden. So whatever they had to do that had to be within reducing clinic burden, eliminate information blocking. So ONC itself was also given the role of eliminating information blocking, and how that is going to tie in is to why this affects you. Redefine certification criteria, which unless you're a certified provider, you don't have to worry about that exact piece right now. And establish implementation timelines for the CURES Act. It was their responsibility to do that, ONC. CMS had a role as well. CMS was asked to expand patient access through APIs, which is a whole nother conversation we can have of what constitutes an API and how data will really start to flow through APIs soon. Health information exchanges and care coordination across payers. For the most part, payers had been exempt from much of health information sharing, and CMS's role was really put in place to help stop that. To really improve dual eligibility experiences, you know, people that were Medicare and Medicaid eligible really have had difficulty with healthcare in balancing the payer and the services that can be provided. That's a little less in California because of your system. Public reporting and prevention of information blocking. And the national coordinator took this on as one of their major pieces. And of course, advancing interoperability. That was, as I mentioned, probably one of the largest pieces of the rule. So it talks about actors, and who are the actors? You're an actor. You're a healthcare provider. I'll define that in a second, but you are one of the actors that is talked about that the rule pertains to. It also pertains to health IT developers. That is your EHR. That is the fine folks from Exym who you are very lucky that you have a quality product and a quality set of people that are going to work with you. This is a big problem for those who don't have a situation where you have a provider who is going to work with you and helping you provide this information in whatever manner you need to provide it. And this pertains to health information networks called HINs, or health information exchanges. You know, a lot of your data goes into these health information exchanges. In New York, we have these things called RIOs, they're regional health information exchanges. In many states, they're statewide health information exchanges. New Jersey's is the New Jersey Health Information Exchange. They're now considered part of this rule and also have to be able to share information that they have access or the ability or are storing on behalf of individuals. The next piece I did want to talk about is that healthcare provider is expansive, and it doesn't only pertain to those that are complying with promoting interoperability programs, which are the meaningful use program. They are value-based treatment programs. They're MIPS programs, measures that improve services programs. So, you know, the original way this had come out was people had thought, oh, if I'm not using a certified EHR, or if I don't have certified providers or practitioners that are part of my program, this isn't going to pertain to me. But it was very clearly squashed, that idea, when they said that, no, we won't be able to affect your certification, but we will put in place other kinds of penalties. Many of those are undefined at this point, that if you're found blocking information that should have been shared based on the information blocking rule. So it's supposed to say we are, sorry. We're not certified, this pertains to us. Here's the piece that really says that it pertains to you. Any individual or entity that meets the definition of at least one category of an actor, in this case, health provider, they're subject to information blocking. And for information blocking regulations, 45 CFR Part 171, and if you're bored, you can read that, apply to healthcare providers, and it's defined in the Public Service Act, which is 171.102. So regardless of whether that HIT provider uses a certified product under the ONC health certification product does not matter. You're still subject to not blocking someone's information. California really has a very broad definition, much broader than what the federal government classifies healthcare providers as. And I'm quite sure that every single one of you, by virtue of who you are and what services you provide, are considered a healthcare provider within the state of California, or actually within any state, because most states have a much more defined definition. So let's talk about what it is that really would make you or an entity an information blocker. There's certain elements that have to be met. You have to be regulated by the information blocking provisions. So for argument's sake, and you can argue this with your lawyer, that you are not a part of this, I'm going to tell you that you 99.9% are considered an actor and need to be concerned about this. You have electronic health information. If you have an electronic health record, you are storing electronic health information. That is your information that your EHR stores. If you commit a practice that is interfering, preventing, or discouraging access to that data, if you have knowledge that you're an actor, and you should, and that information is not exempt based on law or is not covered by a exemption, you must share that information. So in other words, other than particular pieces of information that an individual states they do not want shared, that fall under a definition within law of that information can't be shared, or it falls into one of the exemptions, which we're going to spend quite a bit of time on, you have to share that information. Now, what is EHI? Because there's a lot of confusion as to what EHI is. There's a new definition as part of the CURES Act as to what EHI is. And it's not a whole lot different than what it used to be, but there are a few different nuances. So EHI refers to electronically protected health information. Excuse me. And it's defined to include a designated record set. Now, one thing to note is that, and I'm going to talk about this a little bit more, if you don't have all the data, then by not sharing that data, you're not to be considered that you're info blocking. You only have the data that you have. You store only certain pieces of data. You don't have x-rays of somebody's broken leg because you're not their primary care practitioner or their specialty provider. So that's not information that if somebody comes knocking at your door and says, I want you to share with me that information, you don't have that information. So you don't have to share it. You do have to share the information, though, that they do request. And there are a lot of exceptions because of the field we're in, such as personal psychiatric notes. Certain pieces of that are not to be shared without written consent, without particular individuals' consent. So some of that information does not have to be shared, and I will, if folks want, I can send you a copy of the latest data set that is falling under the US CDI, which looks like it's most likely going to get accepted sometime around April. And it really does identify what's excluded and what's not. And so you don't have to worry about exchanging that. You shouldn't have a concern with that piece of data. But the EPHI now is a pretty inclusive list of data elements in a lot of different areas. And given the time, we'll try to get a little deeper into that. So what can be requested? So as I mentioned, right now, the CURES Act moved us from the Common Clinical Data Set. Folks probably remember the Common Clinical Data Set only because it was like broadcast. If you wanted to be certified, you had to know this. If you got involved in providing psychiatric services that fell under the meaningful use category, you needed to know all of them and provide certain number of them. but we've now moved into USCDI. And you see USCDI does change things, but we're giving quite a bit of time, over 2 years, to move into the USCDI standard. So even though we're being asked to use the USCDI, USCDI version 1 is not a whole lot different than CCDS. So we will use USCDI. That'll be the data elements. And again, don't panic about this and don't get nervous about this, because probably 85% of these data elements are nothing that you collect information on. On an annual basis, they're going to keep going through them. The USCDI does have new data sets that weren't included before. So the province of data, like where that data came from and who put it in. Clinical notes are now a part of the USCDI. There's a lot more around pediatrics in the USCDI. Address and email and phone number are actually part of that, and that I do know you probably have. So that's probably some data elements that somebody could request that you share with them, but I'm not sure why somebody would request that, but they could. So CURES has a whole bunch of exemptions. And I want to go through this to make sure that you understand those exemptions, because these are what are really going to be those areas that you're going to say, I'm exempt from sharing that data, or that's information that I don't have to share because it falls within one of these exemptions. There's 8 specific exemptions. Let's start with the first one. So if you as an actor identify that this piece of data is not being shared because there's a reasonable belief that it can prevent harm to the patient or someone else, and you meet certain conditions, and there's certain conditions that are identified within this harm exemption, if you meet those conditions, then you can exempt that data from being shared. There's a privacy exemption. This one really deals with information that you're going to block, because by sharing that information, you're violating an individual's privacy. And so you have to make sure one of these are met, though, for you to do that. There was a precondition not satisfied. For example, there was not a consent to share this data by the individual or a party that speaks for the individual. The information that is being requested is through somebody who is not covered by HIPAA. This is a really, really far out one, and I would not think of it as one that you would probably want to be using. There's an individual request that says, I don't want my EHI shared, and that's consistent with the HIPAA rules on consent for sharing information. And your individual requested specifically that a particular piece of information or pieces of information are not shared. So it's almost like someone in this case has to proactively state that you don't want to have that information shared. You wouldn't be going back, you don't really want me to share this information, do you? This would be, you have in place something in your files that says this information that you're requesting is not something this individual wants to have shared. So even though on behalf of them, you're requesting this information, they specifically said to withhold this. And it would require the next step of releasing that information through a consent form. Security exemptions. This is another tricky one, but one that is gaining a lot of attention right now because of a lot of the different breaches that have taken place in hospitals and other providers settings. And that's that an actor is not considered interfering with access, exchange, or use if they are protecting the security of the EHI. And there's a whole set again of conditions that have to be met. I didn't list them all because it would overflow the page. But again, I will make available through at least the access to these security exemptions and the little nuances that go along with each one if folks want that data. This is an interesting one in feasibility exemption. Again, this is not information blocking due to infeasibility, and the conditions for this are there's an uncontrollable event that's taking place and I can't share that information right now. Maybe your EHR has broken down. Maybe there's a power outage. Maybe there's some natural disaster. I don't think COVID was considered a uncontrollable event from this perspective, but it probably should have been. Segmentation, if it's infeasible for you to segment this data because it's into a single data element, multiple pieces. This is another tricky one because interoperability calls for segregation of data elements. So you're really going to have to read closely to see whether you can use this one. I probably would not want to use this one regularly. And then there's something called infeasibility under circumstances. And that's really that the provider has like 10 days to identify that I got the information, but I can't provide that information based on your request right now. And I can't do it because it's infeasible for this reason. There are a list of what might be considered infeasibility. And again, that'll be part of what we share with a more extensive piece of information. An actor could say that data is temporarily unavailable because to provide this to you immediately would degrade the IT performance of our system. And again, there's certain conditions, but this is a temporary piece and not a permanent exemption because the expectation is that you will fix that problem. And I know that this is one that knowing Exym and the folks at Exym, if you can't get access to that data, they're going to be working on it and making sure that you could. This is probably both the most confusing of all the exemptions, but it's also probably the one which a lot of providers, practitioners, I should say, in private practice are looking at. And that's the content and manner exemption. And again, there's a lot more definition to this, but condition is really that the content an actor must provide in response to the request in order to satisfy this exemption doesn't meet the content rules, or that the way that an actor was requested to fulfill this does not meet the manner in which information needed to be requested. So this is one that I think we could probably have a whole session on the manner and exemption, the content and manner exemption. But again, this is an exemption that you might be able to use so that you don't have to fill data. I want to emphasize, though, most of these exemptions are not considered permanent exemptions. You know, unlike certain, like CMS has certain rules around billing, right? Like if you are denied billing and you're allowed to zero fill a data element on a invoice, you could carry that on as long as conditions remain the same. When we're talking about these exemptions, each request has to be reviewed in its entirety against its own set of standards, not against, oh, I just got one like that. You can use that internally to say, this was the argument we made, and that's how you're going to react to it. But you can't say a universal, oh, we're not going to provide anything because it all falls under content and manner exemption, or it falls under the fees exemption. So the fees exemption is a pretty interesting one, and one that is most likely going to be facing some changes because this administration was not 100% behind the way this was interpreted and put into law. And that's that an actor, it's not considered information blocking if an actor charges fees, including fees that result in a reasonable profit margin for accessing, exchanging, or utilizing EHI, providing certain conditions are met. And again, there's that whole list of conditions that have to be met to provide this. HIPAA does set standards for the maximum amount that you can charge. You can't go beyond what rules and laws are in place, but there is a possibility that this one could see some changes that reduce or that increase, I should say, what conditions this can be used under. The worry is that, let's say you as a provider want to make data available to someone, but there's a cost to you. And you have every right to recoup that cost through a reasonable fee that you're charging. But it's not expected that you will continuously charge a reasonable fee on top of the cost of developing that technology to exchange information. So the concept is kind of, when that's paid for, you shouldn't have that as part of your fees, or you should build in only a small portion of recouping the cost and not the whole portion. Hopefully that makes sense. I said it a little tricky and I apologize, but the idea is that there are fees that you can charge, and somebody can't say to you, you're blocking me because you're charging me a fee. Just make sure they're reasonable. There are certain cases where a blocker can use a license where there's certain interoperability elements of EHI that fall under a license that don't allow you to share that information. It could be particular information that they should be getting from an electronic, let me think of a really good, here's a good lab. You may have that lab information, but because of certain licenses you may have in place with a lab, you may not be the one that share that information. So there's conditions that you can look at that would do that. But, I would look closely at these when you have some time, because I don't want you getting panicked about this. And the reason I don't want you getting too panicked about this is that right now you're probably going to get asked by patients, clients, your individuals that you serve, for data. Much of that can be met pretty simply, either through your portal or through a report you can hand to them. It's not until we start really getting into the third-party requests where some of these exemptions are really going to have to take place. And, I'm more than happy to talk to you about certain exemptions. My email address will be up there. I'm more than happy to share information with you based on, meetings that I have around this on a frequent basis. So what can you do right now? Before we go into the Q&A piece of this, I really want to lay out a few things that you can do. One is that you can look at your current policies and procedures. Make sure that you don't have any inherent policies or procedures in place that would prohibit or delay sharing information. If so, you need to modify that information, because you don't want to be audited at some point and somebody look and say, why do you have a policy that says we refuse to share smoking cessation data? You can't have that. So make sure that your language sort of meets with what the CURES Act says about information will be shared unless it falls under a certain exemption or is prohibited by law. That's probably a more safe language to have in place. Current forms that you have in place around permission to release information, or forms that somebody can request information, you should look at those. Make sure they don't have language that request a delay or a not requesting information. We're in a very unique situation, behavioral health, in that we put in certain notes that maybe we don't want to be seen. In that information, it does have exemptions, and you'll see that in the piece. So I wouldn't worry about making sure that you put language in that when somebody says they want information that, again, is not prohibited by law or not prohibited by the information blocking rules, that's done on a fairly quick basis and not delayed. EHR data, what information can you readily make available? What reports can you pull? Know the reports, know how you can get that information, know what can be segregated from data elements. What can you embed into certain parts of your EHR to make sure that that's easily accessible if requested. I would work with my Exym staff around reporting if you need to do that. Excuse me. What can you do to take steps now? Update your forms. Like I said, provide training for all your staff. Really create steps that create a review team. You should have in place a team made up of an administrator, a clinical person, maybe a peer person on your thing, but a group that understands the rules or is good at looking something up or requesting information, that looks at every request and decides whether this is an appropriate request or this fits into one of the exemptions. I can tell you that, a lot of the providers a lot of the EHRs that are on the EHRA, a lot, meaning a percentage of them, I don't want to say the vast majority, are big providers. They're like Epic and, Cerner and these big hospital-based mega EHRs. They've been working with hospitals to start hospitals having regular review teams that meet on a weekly basis that gather up all these requests, and they go through all of these requests and make decisions on whether this is an acceptable data element or not. On a smaller basis, you may want to do that. You may want to carve out certain parts of your staff meetings that really are going to be refused for requests and reasons why you don't want to do that. But really, please have people on that understand the rules. You don't want to be accused of blocking everything. Oh, they're just going to block that information because that information eventually does find its way to the people who are accrediting or certifying or evaluating your program. And the last thing you want to do is have Medicaid or Medicare dollars withheld or state dollars withheld because you're accused of information blocking. Know what to do if somebody does accuse you. Know what your options are. I usually tell people when I do consulting with them, have a contact with a lawyer that you can go to. But you also have the Exym folks. You can call me. What should I do? This person is telling me this is what I've done, and how do I address that? You're really going to want to make sure that you did not practice information blocking. If you did, reverse that right away and provide that information. It's probably not going to stop them from complaining about the fact that you delayed them, but at least you provided it. I think that's one that is always easier to ask forgiveness or something rather than permission, something like that. So provide talking points to use with individuals regarding the difference between request and obligation. One of the things I think you're going to face is people saying, you got to provide everything. You're blocking my information by not providing that. So it's worth having that conversation or having a sheet. I always recommend that people have like a one sheet available to them that's either on their computer or a piece of paper that is some talking points that say, no, we're not blocking this information. This is not information that we record within our EHR for you. You know, this is not a product of the interventions, the services we're providing you. That this may be information that we've gained, that we've looked at for you, but this is not information that we're the primary storer of this information for you. So make sure you have that place. You have that in place. So some final thoughts about what you can do. Have a discussion with your attorney. Know if they understand information blocking. If they don't, then try to reach out and at least have in your Rolodex, which is an old term for those young people, the name of a attorney that is an information blocking specialist, just in case you're accused of it. Understand the exemptions. This is really probably the most important piece. If you want to know more about that, I'm more than happy to share all those conditions, because that's really what distinguishes what information blocking is. We just didn't have time to do all those today. Remember that this is an evolving rule. Tomorrow, something could change on this rule. I hate that as much as you hate that. There's going to be delays. There's going to be modifications. It's going to shift in direction slightly. Many of the pieces of the rule are written that there's going to be certain review periods built into this. There's not going to be certain rules that are taking place. So build that into your expectations. Don't be nervous if you see, oh, they're changing this. We'll get to that and we'll make sure you understand it. Remember the reason that this is being done. It's really the right thing to do. We want people to be more involved in their healthcare. We want people to make sure that they're incentivized, that they are health aware. And for those who don't believe that, you really have no choice. It's a law that we have to do. So with that said, I don't know. I can't see whether we have questions.
I can read some of these questions. David,
Yep.
Thank you so much. This has been so incredibly helpful. I know we are in the final minutes of our hour as well, so we
Oh,
can go through some of these questions, and then what we'll be able to do is we'll provide these questions to David to answer, and what will go out after will be the recording of this as well as answers to these questions, and we'll post them on a web page that you all will have access to. But for now, let's go through some of these questions. Socorro was asking about protection for LGBTQ plus minors who are not out with their parents. David, do you know if this is something that would be in the exemption around harm?
I believe it is, but if you don't mind, I want to double check it because under, did they say that it was underage or
Yeah, it
not
would be
underage, but
minors.
minor age?
Yeah,
I do believe it is, but I will do want to double check, but I believe it's one of the
great.
spelled out conditions. There's also the harm issue, that information could provide harm to that. By sharing that information, it could provide harm.
Yeah.
So there's a couple of different areas that we might be able to look at. It may be a privacy issue that
Mhm.
that information could fall under. It could fall under the harm issue, but I'll definitely look into that for you.
Great, and we can follow up
Yep.
with Sakura and with all the attendees. Um, to skip to a few questions down, just because this relates, Roxana was asking, what's the age of an individual? When we say individual, how young can a client be to be able to consent to sharing or holding their data? Do you know?
Yeah, well, it is by state law, but it's based on the minor. It's based on being a minor and having adult responsibility making that decision. So it's kind of, if you think of this like when you go to the doctor's office and you, your parent had to sign for you because you were considered underage. If you're like 14 or 13 years old, then any release of data has to be approved by someone that is considered a guardian of that person. So it's really based on the age of guardianship within that state. So I think California is 18, isn't it? Or is it 16?
I believe it's 18.
18. Yeah. So 18 would really be the age then where that person can sign for themselves that they consent or don't consent to this information being shared. This is a really personal, well, it was personal to the former um, head of CMS who's not there right now, but this is what happened. I don't know if folks remember. I think it was in Wisconsin when an individual who was a substance user um, had identified that data not be shared. Her parents had done that when she was a minor. She went into care in a hospital, and because that rule was in place, they did not share this data, even though the parents were trying to get this data to share. She was in a coma and was unable to do it. And the lady ended up dying. She was 18 years old, and they had a certain rule in place. So you really want to make sure that I would suggest on this one, check the age. Two, make sure that you're following that consent. And three, have in place something that make sure that person has a healthcare directive
Yeah.
in place. I mean, but I can look into the California perspective on this one. I know in New York, it's 18, certain parts of it are 16, um, but 18 is usually the age.
Great. Thank you. Next question would be from Daniel. What are examples of common practices today where EHR systems and/or EHR are blocking information?
Oh, um, there are situations now where I want to word this the right way. There are EHRs that provide APIs to various third-party applications that they sell. So, for example, there may be certain products that an EHR has that maybe it's a health monitoring app, and you would purchase that health monitoring app, and that data is coming from the EHR that also owns that app. And so they may not want another third party coming in and accessing that data and being able to develop a product similar to the product they have. And so there was certain practices that had taken place where they were not sharing that data because either the provider was telling that person, oh, we don't want you to share this outside of our system. It's a security risk, or it's this risk, or it's that risk. And so the scenario was they wanted to keep that business within their health information technology world and not share that with something that might have been cheaper or even free in the outside. Does that kind of answer what that question was trying to get at, you think?
Yeah, I think so. And Daniel, if you want to provide more, if you have further questions, just let us know. And if we don't get to it here, we can follow up as well.
It was one of the biggest factors in this happening. There were situations where app developers had gone to the federal government, had gone to Congress actually, and had gotten a voice in Congress that were saying that there are health information technology companies that aren't allowing me access to this data, and I can provide this cheaper and safer. And one of them happened to be Apple, by the way, who wanted to have access to this data because they wanted to be able to start to develop apps. And for them to be able to do that, they had to have access to personal health information.
Yeah, absolutely. Oh, okay. We are at the hour.
Oh, I'm sorry. I didn't leave enough time.
No, all good. Everyone, what we'll be able to do is take your really incredible questions, and we'll have David go ahead and answer these. And we will send out a link. And that link will include access to the recording of today's webinar, answers to the questions, and if it's okay with David, also access to his slide deck as well, just so that you all have information. And we'll also have a PDF of the exemptions, because many of you asked to have the details for those as well. But for today, thank you so much for joining. I'll let you all go as we are at the top of the hour. There is a survey when you exit, and that survey will help us continue to bring really great webinars for you all and continue to provide that information to you throughout this year. So thanks again for joining.
Thank you.
And thank you, David, so much for your presentation. This has been so incredibly helpful. We appreciate it.
Thank you all so much.
All right, everybody take good care, and we'll follow up with an email in the next 24 to 48 hours with those answers. Thanks so much.
Bye, everyone.